everybody. We're glad to have you all gathered here again. We had a very good reception to our presentation last month, and we're very glad to be able to present another one for everybody. So we have two presentations today, and we will have a little coffee break time in between. And so we're going to have a presentation about wills and estates, and another one about elder abuse and other abuse of others. So anytime you have any questions, just let us know, and we will pass the mic around each time so everybody can hear. That was one of the feedback we got last time, that people couldn't hear the questions. And I will put this over to Dorothea, who's going to introduce our first speaker. And I'll just say we're very glad to have both our pastors joining us here today, Pastor Trish and Pastor Lindsay, and they're sitting there at the back. So, okay, thank you.
Thank you, Janet. We're happy to have David here this morning. We're happy to have David here this afternoon to speak on wills and estates. He's a member of Holy Spirit. He's a lawyer with the Estate House here in Edmonton. And that firm deals entirely with wills and estates. And David specializes in estate administration. So I'll hand the mic over to him, and thank you and welcome, David.
Good afternoon, everyone. I'm glad to see that people are interested in what I do. I've been doing wills and estates for the last almost 20 years now. It's been an interesting and fulfilling career. As I tell other people, you don't go into wills and estates to make the big money. You do it for the entertainment value. So what do? I spend most of my time doing one of two things. I help people put their affairs in order in contemplation of the inevitable day when we meet our mortality. And then I also help people deal with the aftermath when somebody has passed away. People do pass away with alarming regularity, and things have to be done to sort out what comes next. And sometimes that's not all that complicated. Sometimes it's a real hot mess, and that's what I do. So I'll just give a rundown of what I do when I meet people to put their affairs in order, so you have some idea of what a typical estate planning engagement looks like, and the types of things I ask about, and the things that you would think about. Most of the people I deal with are ordinary folks. I don't deal with the uber wealthy. I'm told they exist, but I haven't seen any of them come through my office yet. Most people are people like us with homes and families, and maybe they've got some savings, and all flavors of variety of family types and challenges that make every family unique. So when I'm meeting with people, I want to know, who are you and who's your family? I want to know what you have, and I want to know what your plans and expectations are. And if you're like a lot of people, most of those answers come fairly quickly to mind. You may not be aware of all the different moving parts and how they work together, and that's part of what I'm there to do, is to help demystify this process and make sense of it all and put together a plan that will, should the day arrive sooner rather than later, that will carry out what you have what you plan for. So when I'm meeting people, obviously I get a sense of where they are in life. Are they younger people? Are they older people? Are they midlife? Are they single, married, separated, divorced, other? It's that other category is complicated, and that's what gives rise to a lot of disconnect in planning, particularly if you don't have a plan together. Other meaning, are you otherwise attached with somebody? In Alberta, and I think most provinces in Canada, we have the concept of common law partners. The actual legal term in Alberta is called adult interdependent partner. And for the most part, people don't debate whether they are or are not common law partners. It generally means two people living together in a relationship of interdependence for 3 years or more. But like all things in law, you can debate whether it has been 3 years. When did it start? When did it end? Are you really living in a relationship of interdependence? Or are you just roommates? Are you boarders? Are you really good friends? How do you hold yourself out to the world? These can have significant consequences should death arise, and because the default rules that apply when a person has not put their affairs in order give significant rights to the surviving spouse or common law partner. And sometimes there is a definite disagreement about whether the surviving partner is or is not a common law partner. And the fight is on. I was involved in one of these about 2 years ago. A lady had, her gentleman partner had passed away, and she was pretty convinced that she was the surviving partner, but the gentleman's children did not. And the gentleman's children really had no relationship with their father. As families go, sometimes they blow apart. And anyways, they of course presented themselves after their father died to claim the healthy estate that he left. And the fight was on about whether well, I'll say the girlfriend, for lack of a better term, was to be involved or not. And I don't know how it turned out, because the fight got so expensive that I was told my services weren't necessarily needed any longer. But that's just how things can go sometimes, and with a significant amount of money at stake, as it were. So best to put your affairs in order. Had the gentleman in question made a will saying, I want this to happen and I don't want this to happen, he could have done that. There would have been no debate. But as it turned out, I was told by his girlfriend and various friends that she presented as witnesses to say that's not what he would have wanted. Doesn't matter what he would have wanted. He didn't say what he wanted in the usual way, so he's stuck with the plan, and the kids are going to get at least half. We know that, because that's the way it works. The only question is whether they're going to get it all. And I don't know, I don't care how many witnesses you can produce to say that's not what he wanted. He didn't have any relationship with his children. I understand, but it's not what he wrote. He didn't write anything, so that's the way it's going to be. She was mortified. Everybody was mortified, but hey, that's the law. So find out what you've got in terms of your family. Do you have children? Do you have adult children? Grandchildren? Do any of those people in your life have special needs? Are they able to make their way in the world on their own? Do they need help? Do they need people to manage money for them? Are they what we would characterize as capacitated adults with horrible judgment? There seems to be a lot of those adults around who you do love dearly because they're your adult children, but they have bad sense with money. Or maybe they're in a relationship that's about to end and you have some hesitation about conferring wealth on them. You're afraid that wealth might be diluted in the eventual breakup of the relationship that your children are in. All sorts of things can be of concern to you as we explore just who's in your family and where they are in life. Do you like your family? Not everybody does. You might like your family. Do they like each other? What kind of show are they going to put on after you're gone? I've seen a lot of families where mom or dad are around and all the adult children behave, but once the last parent is gone, chaos ensues. Bad behavior is on display, and well, if you can see that coming, there are things we might suggest to diffuse that situation. If you even see it coming. Some parents are blissfully unaware that their children loathe each other. And estates and death, they bring, like some families I say are meant to just drift away from each other like the galaxies are drifting apart, so we're told. But death brings them all back together for one last final battle so they can really say what they think of each other and then get on with never, never, ever talking to each other again. If you see that coming, maybe it's best to bring some independence into that situation and not saddle your family members with trying to manage that project. Sometimes that's possible, sometimes it's not. So these are the things I look for as I explore just who's in your family. Are any of your family members receiving public assistance? AISH, there seems to be a lot of folks who are in receipt of AISH. Long story short, if you have too much money, AISH discontinues the help. There's some tricks that AISH lets us get away with to put money in trust and buy a house for the AISH recipient and still qualify them for AISH. AISH can be pretty important to the recipient, not only for the cash that it provides, but for the medical benefits that go along with it. So it's a pretty important benefit to preserve, but if you confer too much wealth on a person, all of a sudden they're offside. So I'm alive to these issues, and well, this is, as I'm gathering the lay of the land, I'm making notes, and we'll come back to put it all together. Assets. After we talk about the family, I want to know what you have and all the different moving parts. And you might think that, well, everything I have, it'll just go according to whatever I say in my will. Well, that's not true. There's a lot of things that go their own way, different ways on death. There's a lot of moving parts. Some of the biggest assets you own are probably going to pass outside of your will. Jointly owned property, if you own a home, if you're married or have a partner, you probably own a home together. Chances are pretty good that you own that home jointly. Joint property typically passes to the surviving joint owner. Doesn't matter what your will says, which is all well and good if that's what you intend, as is usually the case. Jointly owned bank accounts, jointly owned investment accounts, as long as if it's your intent that the surviving joint owner, the joint owner being your spouse or partner, is the one who gets all the money, all is well in the world. Jointly owned property with people other than your spouse, I'm thinking here, jointly owned property that you own with your children, whether it's land, investment accounts, bank accounts, and I know there's a lot of jointly owned property between parents and children. That can be the cause of significant disconnect, because the rules that people think apply are not what they are different than the actual rules. In fact, I think a lot of people would be surprised to learn that if you do own property with your children jointly, and I see this often where folks will put one of their children on as a joint bank account holder so that one of the children can run errands and get access to money. Common knowledge has it that the surviving joint owner keeps the money. Well, the Supreme Court says not so, except nobody reads Supreme Court decisions, so nobody really pays much attention to these things, but they have significant effect, particularly if the account is large, as was the case in the Supreme Court decision that led to all this. There was a gentleman who put $100,000 and change into an investment account and had it joint with his daughter. He had 3 children, and, well, long story short, he died, and the daughter said, well, that's my account. The other 2 children said, I don't think so. That was Dad's money. You were just there to help. Dad hated phoning the broker and dealing with it. You were just there to help. That's our money. That's all of us to share, because that's what Dad's will says. No. That's my money because I'm the joint owner. Supreme Court, in 80 or so pages, said, well, we're going to presume that it's shared money, and it's going to be shared unless you can convince us otherwise. And by the way, you need more than your own say-so that Dad wanted you to have the money. There has to be some external evidence to corroborate your claim that Dad wanted me to have the money, because your own say-so, clearly you've got a position of conflict, you're biased, you're going to only give self-serving evidence. What else have you got? Well, Dad's dead, so he's not going to weigh in. These things are never written down, and the joint agreements that the investment companies, that the banks give you are worthless. They don't resolve anything. And the bank, of course, washes its hands of the problem. So there's a fight, and it comes down to credibility and evidence and lots of lawyer fees, and somebody's really disappointed at the end. best not to leave these things to chance. So when I hear people in doing an interview that they've got jointly owned property with one of their children and they've got other children, that's a red flag for me, and I'll come back to talk about that as we fashion a plan. Other things that people have, you're allowed to appoint beneficiaries for some of your assets. Not all of them, but certain ones, certain big ones. RSPs. Lots of people have RSPs. If you've set one up, you've probably been asked, who do you want to name as your beneficiary? If you name your spouse, fine, that's easy. That's probably what your will says anyways. Most of the wills I write say everything goes to my spouse. And if your RSP goes the same place, all is well. But if you name your children, that's fine too, but I ask the question, what happens if one of your children dies? Most people, and I know this because I write the wills for them, want the share of the deceased child to go to the children of those of the one who died. That's a standard play in the playbook, as it were. But when you have directly designated assets like RSPs and TFSAs and life insurance and all these things, that's not so. It just goes to the surviving beneficiaries. So the children of your deceased child get cut out. That's probably not what you intended. And no one ever probably explained that to you before. So as I'm meeting with people, I'm saying, well, this is how it works. If you're content with that outcome, fine. If that's not what you like, then we need to change that. So I'm bringing things to mind that people haven't often encountered. So RSPs, and then there's this thing, tax on RSPs. It's a lot of people have some pretty sizable RSPs. It's money you've never paid any tax on, and not surprisingly, eventually the government does want the tax. And when you die, you have to pay the tax, and I don't have any magic solutions for that. But you do need to be aware that there's going to be a rather large tax bill, and it's your estate that pays the tax bill. So if you've named a beneficiary, like if you've named one of your children or all of your children or whoever, if that money goes to those people, they get the whole deposit amount. So if you've got $500,000 in your RSP, that's going to the named beneficiaries, the whole thing. What your estate is left with is the tax bill on that payment. So as far as CRA is concerned, you earned $500,000 on your day of death, which gets added to the other income you have in a year and taxed accordingly. That's going to put most people in the highest tax bracket and leave your estate with a tax bill of $200,000, $250,000. Which, as I said, I can't do anything about that, but when you're planning, make sure that you know that there's going to be a big tax bill, and if I've got it in mind, I'm going to leave the RSPs to these people, and I'm going to make provision in my will for these people, that the provision you're making is going to be less $250,000 because your estate pays the tax. Little things like that they don't tell you when you're setting up RSPs. Tax-free savings accounts, you can name beneficiaries for those. Life insurance, you can name beneficiaries for life insurance. Pensions are interesting if you have a pension. If you have a pension, the pension law says it's going to your spouse, whether you like it or not. That's just the way it works. If you do not have a spouse or a common law partner, then you can name a beneficiary, and some do, some don't. If you do, then the pension money goes to that person. And just to make things complicated, the recipient of the pension pays the tax. It's not like RSPs where you pay the tax. I don't make up the tax rules. It's horribly complicated. But again, that's something to know that when we're looking at plans, if you do have some flexibility in allocating your pension benefits, you can name a beneficiary. They will get that money. It can often be substantial money. Anybody teach here? Any teachers? Teachers' pensions are huge. I should have been a teacher. Pensions go to the named beneficiary. If you don't have a beneficiary, or if your beneficiary has died before you, all these things default into your estate and they go through your will. So we look at all these things that are potentially passing outside of your will, and make sure that you're aware of what's going to happen when you die, and make sure that you're comfortable with those consequences. And then I usually play out a few different death scenarios. Okay, let's say you die. Let's say you and your spouse die. Let's say you and your spouse and your children all die at once. Let's say some of your children die before you and some survive. People think, oh my God, what kind of work does this guy do? But it's necessary because we don't know when our time is going to be. And we want it to turn out the way we want it to turn out if any of these things should come to pass. So we drill into it a few layers and create some different scenarios, and I illustrate to you how it turns out in any one or more of those scenarios. We look at your other assets, land, investments, if you own a business, non-registered investments. We talk a little bit about tax, what the tax consequences are of death. I don't claim to have enormous expertise in tax. I'm not a tax lawyer, but I know most of the big things that most people will need to know about on death as it turns to tax. I demystify some of the things that people may not realize. Some people have this idea that if you just put things in joint names, you can avoid paying capital gains tax. I don't know where this myth started. If you have most people will know, of course, you don't pay tax on your principal residence. Your home can increase in value. You don't have to pay capital gains tax on that. But if you have a vacation property or a second piece of land, an apartment, rental property, whatever, if that second piece of property increases in value, you have to pay capital gains tax on that. So somewhere along the line, some people have this idea that, well, I just put it in joint names with my son, who's going to get everything anyways, and I don't have to pay capital gains tax. Oh, if it were only so simple. No, in fact, you might be responsible for paying capital gains tax immediately instead of waiting until you die, because if CRA gets wind of it, and they do eventually, they consider that a disposition of a half interest, and yeah, we want the tax now. There's a lot of urban myth about planning out there that, again, I try to demystify when folks meet with me. And then there's also the possibility that the person you put on joint names with goes rogue on you, and you want it back. Well, you can't just take it back. You've given it to them. Or, perhaps more likely, what happens if they get into financial difficulty? Well, now they own half of whatever it was that was in joint names. Well, I just did that for convenience. Well, sure you did. If you do it properly, and this is something I tend to discourage, but some people insist, we can create what we call bare trusts, where we do have some paperwork to say it's not a true disposition, it's not a true gift, it's only being done to simplify my paperwork on death, and if I ever ask for it back, then the recipient has to give it back if there's ever a falling out. So there are some workarounds to do it if people insist. Sometimes that's necessary. Tax expectations. What do people want to do with their money? Do they want to leave it? Most people and leave it to their spouse if they have one. Leave it to their children equally if they have them. If they don't have children, or if they have children with special needs, we might use trust to have somebody appointed to receive the money on one of the adult's behalf, and that could be because the adult in question is either intellectually unable to manage the property, or they just have poor judgment. You don't have to leave money outright to people that you don't think are good stewards of money. If they've got problems, addictions, spending proclivities, you may not want to leave all your money to the intended recipient because they're just going to squander it. But you love them and you want to see that part of them, that they received money, so we can use a trust to put somebody in charge of the money and say, pay a monthly allowance until the money runs out. You also get to say what happens if the person who's the intended recipient dies before the money runs out. You say, well, if there's any money left over, give it to the other children, or give it to charity, or give it to that person's surviving partner. All sorts of things that people haven't are likely not to have thought about. But again, I lead them through these things to bring them to their attention that they have these options. Any questions so far? Anything I can demystify?
So in terms of if you have a family member that's on AISH and has a disability and you have it set up in your will that you say you have money in trust, if you just say that money in trust, or does the will have to specifically lay out they should, they will be given so much per month, or it's up to the trust when that's formed to kind of organize the specifics of that after? That's one part, because I have that particular situation in my family.
Normally it's a little more descriptive than just money held in trust, but it is not usually so prescriptive as to specify how much money per month. We usually confer the discretion on the trustee to give as much money as the trustee considers appropriate from time to time. So it is a little more detailed, but it's not so rigidly specified that they're hemmed in. It can be if you want to, but most of the time people, you don't know what's coming down after you're gone. So I encourage people to take a very flexible approach. I also encourage people to use things like registered disability savings plans if they have people who would qualify. I think it's a terribly underused program that the feds sponsor. If anybody familiar with that or know anybody who's got one? A registered disability savings plan requires the person in question to have a fairly significant disability, and you have to go to a doctor and they have to fill out some CRA paperwork to establish the disability. You send it into CRA and they review it, and eventually they will say, yes, that meets our criteria, or no, it does not. If it does, then the person in question gets a disability tax credit, which may or may not be important to them. If they don't have any income to tax, then a tax credit is no real use to them. However, what it does is it enables them to have a registered disability savings plan set up for them in their name. You have to be 49 or younger to set one up. There are contribution limits, of course. Well, let's suppose you've got a young adult person who's severely disabled and you want to set one up. You get your doctor's notes and you send it to the CRA. CRA says, yep, you pass, and you go to your bank or brokerage of choice and say, I want to set up an RDSP. Great. They'll have you sign some forms. You put in $150. And the feds will match your first $50 3-to-1. And then they will match the next $100 2-to-1. So your $150 immediately turns into $500. And plus you get to earn interest on that, tax-free. That's not a bad return. Like, if the government's giving out money, get in line. Get your share. It is exempt from AISH. So remember when I said that if you have too much money, AISH says you don't need our help. If they don't count, they simply do not count the money that's in an RDSP. So this is one of the tools I will use to say, well, you want to leave some money to your son who's on AISH? Well, they've got an RDSP, as it turns out, with some unused contribution rooms. So let's put a whole bunch of money in there to top it up. And it's, all of a sudden, AISH doesn't count that money and their eligibility is preserved. The money grows tax-free. When the money does eventually come out, it's paid to the recipient and taxed at the recipient's rates when it eventually does come out. It's a fascinating program for those who qualify. It's a hassle because you have to go to a doctor and you have to get forms. You got to send stuff into CRA, and it's not terribly well promoted by the financial institutions, but it's there. It comes out. The rules are a little complicated because it involves tax, but it can come out at any time. Preferably, the money that you put in stays in for at least 10 years, and then it can come out, including the portions that the feds have given you. If you take money out before the 10 years, they have this horribly complicated algorithm to figure out what share of the money belongs to the feds because they want their money back. They're fine with you keeping it so long as you've let it sit there and their contribution to top up your contribution has grown for at least 10 years. They're content for you to keep that. But what they don't want is for you to put in your $150 and then immediately cash out the $500. That's offside. They want their $350 back. But it can come out anytime after the 10 years, basically. And it's intended to be a long-term financial support for a disabled person in their later years. It's a fantastic tool.
If somebody's on, if I have a child on AISH, is that sufficient justification to set one up, or the feds will?
No, the Tax Act specifies, and I can't remember the exact wording, but a severe and prolonged disability, I think, is what's required to qualify for the disability tax credit and the disability tax certificate. But if your child's on AISH, I'd say it's worth asking. All they can say is no. Either you either meet the test or you don't, and it's absolutely worth looking into. Oh no! You can make contributions throughout your life up until age 49, I believe, or 59. I can't remember.
Did you have a question?
The person for whom this fund is being established. Once they get to be 59, you can't put any more money in. And I think you have to set it up by 49. I think you're permitted to contribute until they turn 59, following which no more contributions, and then it's...
Don't touch anything, just talk. Sorry, can I just trouble you to use the mic, sir? Just because we're...
Oh, sorry. The question is about how much can you contribute? Is it a one-time contribution? Is it a something you do ongoing? The answer is, yeah, you can make annual contributions. There are, lifetime contribution limits, but it's fairly generous.
And sorry, so if I put in the first 50, they triple it, and then the second 100, they double.
Yeah.
And after that, they continue doubling, or what?
No, they don't. Then they're done.
Oh, okay.
But
so you want to put in a big sum to start.
Yeah, you can put in, say, $5,000 as a deposit. They'll give you a top up on the first 150 to turn it into 500. But the rest of it just is it's an investment in the savings plan, which then grows tax free or tax deferred. I can't remember. Sometimes I confuse it with the education savings plans. I have those for my kids now, and they're in university, and thank goodness I have savings plans for them. But
I think we have another question here.
Yeah, this is just a little off the topic, but if you have, say, like your RRSPs, tax-free savings accounts, some sort of pension, and they're all in the same bank, do you have to identify each one of those, or can you just say everything that's in the bank goes to such and such a person? Or
you will, if you wanted to change your beneficiary, the bank would probably have you sign a beneficiary change form for each asset category. So you would sign one for your RSP, one for your TFSA. I don't think they would do it global. It's between you and the bank, because it's the bank that has the plan that you are a member of that governs what happens to those particular assets. And I would be surprised if they had global beneficiary change forms. I just haven't seen that yet.
Thank you.
Is there any other questions? Okay, okay. I'll come back to you. You want to go first?
I have a question about probate.
Okay.
So probate, I understand, is whether you go through probate or not is largely based on the amount of your assets you have and whether or not there's property. And I'm probably way oversimplifying that. But can you speak a little bit to like what's the sort of threshold that an estate has to go through probate, or how can probate be kind of avoided? Or
Sure, that's what I do with the other chunk of my time, is help people when somebody dies, and that usually involves whether probate is needed. Probate is probably misunderstood as a concept more than anything. Generally, probate means you present the will to the court and say, this is the last will of the deceased person. I'm not aware of any other wills that came after. The court will look to see, has it been properly witnessed? Has it been properly signed, dated? Have you informed all of the people that are named in this will of the fact that this person has died and they're named in the will? Have you given appropriate notice to all the family members who have potential claims against the estate but who have not been mentioned in the will? If so, the court says, well, I guess this is the last will, and they put a seal on it and you're probated. You need probate only to, it's a tool that enables you to do your job as executor. An executor's job is to gather in the assets of the deceased person, pay their debts, and eventually distribute what's left over. You just can't go down to a bank and say, I've got this will, can I have the money? If there's a lot of money in the bank is going to be very hesitant to give you that money just because you produced a piece of paper that looks like a will, but what do they know? I mean, they don't know if it could be fraudulent. The person who signed it might have made other wills. They might have divorced. All sorts of things could happen that cause the validity of the will to be called into question. Probate is that official function which comforts asset holders that they can turn over the property to the person who's the executor. So it's not so much that the court or the government cares whether you probate the will. In fact, they don't. There's even a section in the Estate Administration Act which says how what one must do if you are administering an estate without probate. Practicality is such that before you're going to get that money out of the bank, before you're going to get the life insurance that's payable to the estate, or before you're going to get the land titles office to recognize your authority to sign transfer documents to sell the person's house, you've got to get a grant of probate. Happily for Albertans, we do not have a probate tax. Unlike every other province, we pay a court fee that caps out at $525 once the gross value of the estate, or the net value of the estate, is $250,000. So most people have to pay a court fee of $525 to probate the will, and that's it. If you're in other, like BC, I think it's 1.5% on your full net wealth. So if you've got $1 million estate, that's a $15,000 tax. In Alberta, it's $525. It used to take a long time to get that sealed probate out of the court. It used to take months. I'm happy to say that in the past couple of years, the court has implemented some significant streamlining to the point where a lot of these wills can be probated in 2 to 3 weeks. So it does speed up that part of the process significantly. Probate is where they sort out if there's going to be a fight. And people talk about, well, challenge the will. What does it mean to challenge the will? When can wills be challenged? Falls into a couple main categories. One, if a person thinks that the person who made the will lacked the mental capacity to understand what they were doing, you can challenge that will, but you'd better have some evidence. And you don't have to have a deep understanding of the world and all its complicatedness to make a will. It's a pretty basic threshold. Do you appreciate the nature of the act when you're signing this paper? Do you understand that you're making arrangements to dispose of your wealth at death? That's basic test number one. Test number two, do you understand basically what you have? And we don't need to know down to the penny. You don't need to know down to the penny. You need to know, yeah, I own a house. How much is it worth? I don't know, lots. Okay, close enough. I've got some money in the bank. I've got some stocks. I think they're worth this much-ish. Okay, all right, you've got a basic understanding that you've got money. Now, some people are completely misguided. Remember Rain Man, the movie? What was the question? What is this worth? Oh, about $100. What's that car worth, Raymond? Oh, about $100. Okay, Raymond didn't have capacity, but most other people are going to understand what they have. They also have to have some appreciation of who has expectations. Who's waiting in the wings to get your money? Mainly your offspring. Are you aware that you have offspring? If you have trouble recollecting that you have offspring, that's not going to turn out well for you. It happens. I had one gentleman who was telling me a lot about his deceased wife, and she'd been gone for a few years, and no, we're not going to finish this one. Poor guy. And is there any evidence that you're suffering delusions? Are you delusional in a way that is affecting your judgment? If you are suffering paranoid delusions that you think your children are stealing from you, when in fact they're not, that influences the decisions that you're making. I'm not leaving anything to my children because they're stealing from me. I've got lots of money, and yeah, I know I'm making a will, but your judgment is clouded by a delusion that goes to the act of what you're doing. That puts you offside. The capacity challenges are quite rare because the test is really quite basic to pass. They happen, but it's rare. Another will challenge is if a person has been unduly influenced. Undue influence is it's sort of like duress, except it's not quite as physical. Like, you understand the gun to the head, sign it, or your name or the brains are going on the will or something to that effect. Okay, that's not a free expression of giving. So that will's not valid. That's extremely rare. Haven't had one of those. But I do have allegations of somebody unfairly and unduly pressuring someone to make a will. And that's really hard to prove. If somebody is making your life unbearable to make a choice that you don't want to make, but you feel you have no alternative but to do it, that's not a free expression of giving. That is undue influence, and the court will set that aside if it can be proven. Now, of course, nobody does this in the presence of witnesses, so it has to be constructed through circumstantial evidence. And a lot of people who assert undue influence are really just mad or disappointed that they've been left out. And sometimes that's okay. They're extremely hard cases to try. They're often asserted, rarely successful. But if you can pull it off, the court will set it aside. There was one case a couple of years ago which involved a lady who is it fair to say she was sponging off a guy and kept promising, oh, we'll get married someday, we'll get married someday. She had no intention of marrying him, but she wanted to be in the will and et cetera, et cetera. Anyway, so the guy changed his will and included the woman with whom he was obviously quite enamored. She had no intention of marrying him. This all came out at a trial, and the court said, no, he wouldn't have done that were it not for the pressure that you put on him, and you weren't genuine in your intent, so we're going to set this aside. That's pretty rare. That's very rare. What is more common is the provision that a person must make for their spouses. You must make provision for your spouse in your will. You must make provision for a common law partner if you have one. You must make provision for minor children if you have some. You must make provision for your adult children who can't earn a living because they're disabled, physically or mentally.
Yeah, no, it's okay. David had a question here, so we'll let him.
This will be quick, I hope. Pensions. If you're single and you're receiving a pension already,
Yes.
one thing you could do is leave that pension to your beneficiary.
Yes.
Now, the beneficiary, as I understand, would pay taxes on that.
Yes.
Can you leave it to your estate instead?
Yes. And your state will pay tax on it.
Yeah.
And it's a lump sum payment at that point. So if you're a single person in receipt of a pension, and you die, if there are residual benefits to be paid out to you after death, they will be paid either to your named beneficiary, who then receives a lump sum payment and pays tax on it, or it will be paid to your estate, receives a lump sum and pays
The
tax on it.
estate pays tax.
Yes.
Thanks.
Any other specific questions, Rita? And okay.
Yeah, I'm kind of a slow learner, sorry. Back to probate
Yeah.
for me, if you would. You said something about probate comforts asset holders or asset, okay, fine. So do I hear you say that probate is a good thing and every will should go to probate? If there's no property, does it have to go to probate?
If you can get, if you as the executor can get the assets dealt with, you don't need to probate the will. If the deceased person has $2,000 in the bank and you are the surviving partner, you can probably convince the bank to just give you the $2,000. You can show them the will, and the bank will probably say, well, here, sign this indemnity agreement that says if it turns out that you're not the person entitled to it, then you pay it back. And you'll say, yeah, okay, fine.
Okay, we do a lot of traveling. So if we both wiped out on the highway,
Yep.
our kids live in the U.S. We have not named them as executors, so
Okay.
they don't have to pay U.S. tax. We have Alberta executors
Okay.
who we know and who our kids know, and we're comfortable with that.
Okay.
So, and if there's no property, then the executors can, like you say, if they can get a hold of, or talk to the right people and the bank, or
Yeah. Now, when you say property, are you meaning land, or are you meaning like assets?
nothing, no land, no house, no
land,
nothing.
No land, no money.
Hopefully, we get no house by the time we're dead.
Okay. Well,
We're
if
working on it.
if probate, as I said, it's a tool that the executor uses to establish their authority
Yeah.
to convince whoever is holding your stuff to give it to them.
Okay.
If they can convince the institution to give them your stuff, whether it's money or stock
Okay.
or whatever, they don't need to grant the probate. Most institutions have internal thresholds that they decide for themselves, and it varies from bank to bank. 20,000, 30,000, 40,000 sometimes. There is a discretion factor. It sounds to me like the individual branch managers have a fair amount of authority to waive requirements. And it kind of depends on, do they know you? Do they have a relationship with you? And what's the comfort level with the will that's being presented? I've seen some pretty sketchy wills. I've got one that I put through the court recently. It was written on the back of a cigarette pack. Did the job, but I don't think the bank would have taken a lot of comfort in that. But now that I've got the grant of probate, hey.
So just to confirm, just to sort of follow up question to Rita's, if you have to, it depends also on the amount of assets you have. There's a threshold whether your will needs to go to probate or not.
Only because the institutions impose that. It's not a government rule.
Mm-hmm.
If you've only got $20,000 in the bank might give the money to your executor on presenting a copy of the will. If you've got $100,000, it's much less likely that anybody is going to give you that money, because if it's wrong, if somebody else shows up with a probated will and says, I'm here for the $100,000 that Jack had in the bank, they have to pay twice, and then they got to go find the rogue and try to get their money back. Well, that's just not on. So They say, go get your grant of probate and I'll give you the money.
Okay, so we've got a question here and then one over there.
So it's more of a theoretical question. Have you dealt with people who have undergone the maid way, medical assistance in dying?
I have.
How does that work for
They die.
I know they die. They wanted to.
Yes. I mean, some people have come to me to put their affairs in order, telling me I've made arrangements with maid and I'm going out. Well, the lady who I'm thinking of, she had been a client of mine, and I had written wills for her before, and as her life evolved, I updated them from time to time. And then one day she announced that she had terminal cancer, and she'd opted for maid, and she was doing one last update to her will, and we updated her documents, and a month later she was gone. And
Okay, I have a question. Does your executor have asset to your bank accounts to continue paying your utilities if you have property and condo fees, etc.?
after they get probate, they will, yes.
So they have to have probate before.
Yes, and this is why it was such a hassle when it took 6 months to get a grant of probate.
Wow.
And in the meantime, bills either went unpaid, and utility companies were usually okay with that, or somebody paid them and then eventually got reimbursed. And sometimes I've seen it done where the bank will just pay the utility company because they know that that's an expense that has to be paid. You would think that this would be better defined, but it isn't. It's like the first time somebody ever dies when you go to the bank. Oh, I don't know. I don't know what to do. Well, people die all the time. We're not your first customer to have died. But
I just have a question about this term trustee. Is that what you would do? Like, can you have a trustee and executors as well?
yeah, I'll explain the difference between executor and trustee. An executor is the person who deals with all of the aftermath after your death, the immediate aftermath. So you die, whatever is you've left behind, your executor parachutes into that situation and deals with it. If you've got a house, they've got to take command of the house, secure it, arrange its eventual sale. If you've got bank accounts, investments, they got to collapse all that, get it all pooled into one pot of money, and pay any bills, pay any taxes that you owe. And once all the debts have been settled, now they're in a position to distribute. Your will presumably says who gets what. If the will says distribute the money as soon as you can, the executor does that. But if you've got a young person, for example, or a person who's disabled, and you say, well, don't distribute the money immediately. Hold the money for them until they're 25. And in the meantime, give them a little bit of money as and when they need it. And then when they turn 25, give them whatever's left over. Or if you've got a disabled person, take the share for them, hold it, invest it, make it grow, give them money as they need it until they die or the money runs out. When the person so the executor becomes a trustee when that distribution occurs. So if the executor is distributing to a beneficiary, their job is done. But if you've instructed the executor to hold the money, that's when the executor transitions from executor to trustee, and they switch hats, and now they're wearing their trustee hat. Everybody else has been paid their inheritance, but you have, I'm not to give you the money entirely. I'm supposed to hold it as trustee and pay it out to you over time. You can have different individuals if you want to. You can say, I want this person to be my executor, but I want this person to be the trustee of the money I've set aside for this person.
So can you just have a trustee and no executor?
No, somebody has
You have to
to
have
attend
both.
to all the things that need doing when you die.
Okay.
It's my understanding that if you own land, you have to probate because,
Pretty much.
yeah, land titles won't take.
Yeah, land titles are really quite formal in their requirements. You can get a court order instructing the land titles office to do something, and from time to time I have used that process. Usually when the person has no other asset and they've got a piece of land and everything goes to the surviving spouse, and for some reason the land was in the deceased spouse's sole name. Sometimes I can get on bended knee at court and say, can we just, and sometimes they'll give me that order. Some judges will say, no, there's a process, it's there for a reason, no, go use it.
Yeah, that was a situation I had. I did a individual estate because that's all there was. There was a few dollars in the bank,
Yeah.
and then the land. But what was really interesting with that is I did get probate,
Yeah.
and when I took it to the bank,
Yeah.
she told me, how do I know that this is real?
Because it says so.
Yeah,
That's what the
well,
court, it's the whole point of probate.
Exactly, but it was almost as if because I wasn't a lawyer or a representative of a law office, so there was a whole schmozzle. It took me a whole day to get all of that clear.
Yeah, I found now that most individual executors like yourself have far better dealings with banks than me as the lawyer. They routinely ignore my letters, it seems. I send a customer down there to pound on the desk, they get attention.
Any other questions people had?
It's on, Paul.
Does a distribution have to be in cash or can be done in kind?
Oh, it can be in kind. Usually the will says something like, divide everything equally between my children. So you've got 3 children, everybody's going to get a third. But you've got some stuff. So the executor can say, most wills confer discretion on the executor to distribute in kind, and it permits the executor to settle disputes about how much things are worth. So let's say you've got a house, and one of your kids wants the house, and your executor says, okay, I think that's a good plan. You're going to get the house, and for purposes of accounting and distribution, I'm saying the house is worth $400,000, which the executor in good faith and with reasonableness thinks is a fair amount. You get $400,000, and you people, or $400,000 in house, and you get $400,000 in cash. You get $400,000 in cash, or stocks, or quads, lawnmowers, record collections, whatever. Yeah, you can. It's normally the executor can settle those disputes. If the will doesn't confer that authority on the executor, then the executor is supposed to get permission from all of the beneficiaries before they distribute items in kind. So this is where it can get problematic if there are things that are sentimentally important and the person has died without a will. Whoever's in charge of the estate cannot make executive decisions to say, well, you're getting the stamp collection. If you can't agree, if you can't get everybody on board, you have to sell the stamp collection. Then they split the money. So, but most of the time, people are agreed that, okay, well, we'll just make adjustments to the money amounts so that we all come out with an equal amount of money.
Yeah, I was just wondering, does Canada recognize, and probably Alberta more, do they recognize these will kits?
Oh, yeah. Yeah. There's no requirement that wills be written with lawyers. Wills must be written. They must be signed by the will maker, the testator. They must be witnessed by 2 people, preferably people who are not beneficiaries, and they are not spouses of the beneficiaries, to give the independence. So yeah, you can go get a will kit and write in whatever you think you want to do, and if it's witnessed by 2 independent people, present that. And I have presented a lot of will kit wills to court for probate, and the cigarette pack will, and the napkin will, and some other interesting things. Those are all testamentary documents. I've also probated handwritten wills. So if you, in your own handwriting, write a will and sign it, you do not have to have witnesses.
Oh, you don't?
No, because your handwriting is the comfort that this is your authentic expression. They're called holograph wills. I've probated quite a few of those. Sometimes they say enough to get the job done. Sometimes they don't. Sometimes they're woefully inadequate. At one probate, we were presented with one holograph will. It was gibberish. I mean, I don't know where the guy's head was at. We just didn't know what he was trying to say. So we gathered the family and said, "What do you want to do?" And we made a deal. But you do not need a lot of formality. You will get the will that you write, which may or may not achieve the end that is best for you if you don't know, for example, that my RSPs pass outside and joint property does something different. So the benefit of doing wills with counsel is that we'll look at the whole big picture and you'll know that it's done properly.
Okay, big question. What would be sort of the typical cost of writing a will these days with the powers of?
Yep.
And is it like for going through the estate, is that like a flat fee? Is it a percentage fee? What kind of thing could a person expect then in terms of those costs?
Okay. Writing wills, expect to pay somewhere between, you could probably find them for $750 to $1,500 per couple. My usual fee is $1,100 per couple. I've got associates in my office who do it for $900. Their time's a little more affordable than mine. There are certainly lawyers who charge more. There are some lawyers who will charge less. I think it's somewhat of a function that you get what you pay for. If it's too cheap, then you're not getting a whole lot of lawyer attention, which I think is a disservice, but that's just me. When you probate expenses, that's all over the map. There's a suggested guideline that lawyers follow. It's 1% of the estate. But like many things in life, it's negotiable. If somebody comes into me with a $2 million estate and it's 2 big GICs and there's only one beneficiary, that's a $20,000 bill to fill out some forms and transfer an account. That's a good payday for me if I can do it. And some part of me says that's wrong, so I will negotiate. At the same time, I am trying to run a business, and I think I mentioned at the beginning, you don't make the big money in wills and estates. So we don't make a lot of money writing wills. We make some money probating estates. We can make a lot of money. We can earn a lot of fees in fighting over estates because it's very time consumptive, and most of what lawyers do is by the hour. And if people want to get into a years-long battle over whatever, hey, we're here to serve by the hour. We'll bill you monthly.
Just a couple quick questions. You were alluding to if you've got specific items, some antique car or
Yes.
whatever, or specific sentimental items. Is it best to prevent any disputes to list specific bigger items like that in your will?
I think it is. If there are important things that you do want to see go to certain people, then by all means, I write them into the will. For everything else, I have and many lawyers will have a clause that gives the executor discretion to divide up the personal items as the executor sees fit. We will then go on to say the dying person, I might leave a list to guide the executor. It's not a legally binding list because it doesn't have all the bells and whistles of formal execution, but I kind of want my executor to do what I asked. And if you're a good person, I mean, you do get to pick your executor. Chances are really good they're going to carry out your wishes. That works most of the time. But you certainly can put things into the will, in which case it is a legal obligation to deliver. That takes a lot of guesswork out of things.
And do most people have their spouse as their executor? And then my last
Yes.
question, if it's a second marriage,
Yes.
in terms of prenups, how that affects versus the will?
If the surviving spouses to get everything, as is often the case in their first marriage, then yes, it makes sense for the spouse to be the executor because they're going to attend all this paperwork and transfer everything to themselves. They'll probably hire somebody like me to guide them through that process. I'll get them there, but they're the boss of the process. If it's a second spouse or a second marriage and the new spouse isn't getting everything, then quite often it's not the spouse that's the executor. Sometimes there are committees of executor. There could be a surviving spouse and one of the deceased's adult children. Generally, I don't like committees. They can be problematic, but so you can have different executors. Prenups are often they say that if our relationship ends, you take what's yours, I'll keep what's mine, and that's that. A prenup will often say that the surviving spouse will make no claims on the estate of the dying spouse. However, the dying spouse may choose to leave gifts to the surviving spouse, and they often do. What a lot of people don't know, and I don't know how often the family lawyers tell their clients this, those prenuptial agreements that say you will not make claims against my estate are not legally binding. They are against public policy because remedial legislation says you must make adequate provision for your surviving spouse. And a surviving spouse cannot contract out of that right to remedial assistance from legislation. It will shape the type of what's adequate. If the surviving spouse were to say, yeah, I know what I signed, but I'm destitute and I don't have any money, and he had tons. The court does have the authority to make allowance out of the deceased person's estate. And the other beneficiaries will say, wait, she contracted out. And the court will say, yeah, but that's void as against public policy. We're not going to confer a large award because we do recognize that they did have an understanding and it was documented and contracted. So that's going to shape our remedy, but it is not a bar the way some people believe. That comes as news to some people, that the court can rewrite wills. That is the most common type of challenge. When people are challenging wills, it's because there's a family member that fits into one of the distinct categories of people who do have the ability to say, I think I deserve more. It's a very limited class in Alberta and most provinces. BC is entirely different. Don't die there. But in Alberta, you must make provision for your family members, spouse, common law, minor children, adult children with disabilities. Beyond that, you can do whatever you want. If you want to cut out your able-bodied, able-minded adult children, you can do that. You can be capricious, you can be mean-spirited, unfair, unjust, but it's permissible. You cannot, as an adult child, just say, oh, that's not fair. It's a non-starter here. But if you are disabled and you can't earn a living, well, now you've got grounds. So, anyways, I could go on for days like this.
No, just looking at our time, we have probably about 2 minutes or 3 minutes left. So just a couple more questions, and then we'll have a little bit of a break here.
Just a quick question. How many executors are you allowed to have? Can you have one or three, and do they have to be in the province or in Edmonton or whatever?
You can have as many as you want.
You can list a number of people.
Yeah, you can have a committee if you want. At some point, it becomes unworkable. I find, like a lot of people will have two because they think that the two will get along, and usually they do. They share the pain. They trip over each other sometimes, and I have to burden them to have them both come in and sign documents at separate times. Three can work. Hopefully there's a majority rules clause to break ties if there's something that they need to decide upon and cannot get unanimity. Do they have to be local? They do not. You can appoint executors anywhere. I strongly encourage you to not appoint non-resident Canadians. So anybody who's not a resident Canadian, there's no legal bar to them acting as executor, but it will complicate things because it adds layers and layers of red tape for tax purposes. Your estate becomes a non-resident taxable entity, which just messy. You can have, a lot of people think you must be within the province. You do not. You can have extra provincial executors. When you die, the beneficiaries, there's a default requirement that non-Alberta executors have to post a security bond so that if they take the estate money and disappear, the beneficiaries can look to this security bond and receive an inheritance. Then the security provider goes and tracks down the rogue and tries to get their money back. 99% of the time, the beneficiaries will confirm to the court that's unnecessary. And when they do, the court will say, we don't need any security from you. In all the estates I've probated, I've only ever had to get one bond because the beneficiaries in all the other cases have said, no, we trust Uncle Jack from Ontario to get it done. And most of the time they do.
Any your last, I guess perhaps a chance for one more question. Anybody? Okay.
Do executors get paid a fee out of the estate?
They do. They're entitled to fair and reasonable compensation for their time and troubles, whatever that means. There's a suggested guide that says somewhere between, first of all, there's a number of factors listed in the surrogate rules, gloriously vague and helpful of nothing. But general understanding, as confirmed by a number of court decisions, is usually in the range of 2 to 5% of the gross value of the estate. But they will look at things like, well, how big is this estate? 5% of 10 million, that's a lot of money. Did you actually work for that money? How much time did you really spend doing it? How many, what issues did you have to confront? If this was really easy, we're going to lower you down on that percentage scale. But if this was a real burden, and it can be, then it's at the higher end. And you're not capped at 5%. A lot of people die with very modest estates, 50 grand. Well, 5% of 50 grand is, it's what, $2,500 bucks? If you've got a well, they wouldn't necessarily have a house if they've only got 50 grand, but maybe they do. They might have a house that's heavily mortgaged and they've spent all the money. They got to clean that house. They got to sell it. They got to deal with all the junk. They got to file taxes. They got to meet with lawyers and accountants. The court can say, yeah, I think 5% is a little thin, so we're going to bump that up. Normally, the executor, as the work is winding down, will make a proposal to the beneficiaries to say, having regard to these gloriously vague factors listed and having regard to the usual practice of something between 2 and 5%, I propose I get paid this. And if all the beneficiaries agree, that's that.
Can you name that percentage in your will?
You can specify the compensation in the will. Most don't. I generally discourage it because you don't know really how hard it's going to be. Your state of affairs today might be very different 20 years from now. And if you're like most people, you don't update your will.
And is that taxable to, to the executor?
Oh, yeah, of course. Taxable income and subject to CPP premiums.
Okay, cool.
Not EI. So then the estate's got to register as a payroll, get a CRA number, and do withholdings and remittances and file T4s and, red tape aplenty. Yeah. But yes, you get paid. And if you can't agree with the beneficiaries, the court will settle it for you if you can't come to terms, but that's extremely rare.
So maybe all the beneficiaries should just agree to pay that person a little bit.
I didn't hear that. That would be tax evasion, but I'm sure a lot of things go on in the world that probably CRA would disapprove of, but I can't counsel that.
Well, thank you very much, David, for your very informative presentation and information. There we go. According to our schedule, Paul, we are going to take how many minute break? And And so then we'll have our next speaker. So we'll start at 22. Okay, thank you.